I've heard some commentary about some of the topics that are coming up in this request for information may actually require congressional approval instead of just an agency change.
There's a provision in TILA and a provision in RESPA that says, hey, CFPB, you've got to issue integrated disclosures, and that's it. And it gives the CFPB a lot of discretion. There's certain required information that needs to be included in the forms, but there's not a lot of specific guidance on how to accomplish that. Now, there are certain areas of TRID that might go further than a court thinks that Congress gave it discretion. There's nothing in the statute that requires something like the tolerances. That could be an area where industry says CFPB didn't have the statutory authority to promulgate these tolerances. It's not within your discretion that Congress gave you. You can see how that argument can be played out.
Last week, we talked about what the CFPB is considering changing. And today, we're talking about something just as important: what happens next. If you've ever read a request for information or a proposed rule and thought, well, I'd love to weigh in, but I don't know where to start, this episode is for you. Welcome back to Keys to Real Estate. Rich Horn has been on the inside of this process. He knows how agencies evaluate comments, what makes them useful, where Congress ends and an agency's authority begins, and why thoughtful feedback from industry professionals really can influence the final work product. You don't need a law degree to participate. You need experience, good examples, and a willingness to share them. Let's talk about how the process actually works with the man we lovingly refer to as the godfather of the TRID rule and friend of the pod, Mr. Rich Horn. The presenting sponsor for this season of Keys to Real Estate is TrustLink. TrustLink brings clarity and control to trust accounting for title and escrow companies. Their specialized solutions are designed to simplify reconciliation, strengthen compliance, and safeguard client funds, helping your operations run with a greater confidence and precision. With TrustLink, you gain access to a dedicated team of experts focused on daily three-way reconciliation, unclaimed property management, and tax reporting services, giving you the visibility and accuracy needed to stay ahead of complex regulatory requirements. TrustLink is also recognized as an elite provider by the American Land Title Association, highlighting their commitment to delivering trusted, high-quality solutions to the industry. Backed by more than 50 years of experience, they've built a reputation for reliability, accuracy, and service. With deep expertise, purpose-built solutions, and a focus on accountability, they are elevating the standard for trust accounting. The future of secure, streamlined trust accounting starts with TrustLink. So visit trustlinkservices.com to learn more. Rich, welcome back to Keys to Real Estate for a second week. We need you.
Yeah, my pleasure. Thanks. We had such a fun time the first discussion. Happy to be back.
We sure did. We sure did. Well, there are some folks that haven't been through a change process, a change cycle yet to know kind of how it goes. So they might have been thinking after last week's and after reading the RFI, boy, I've got some thoughts. I would really like to share them, but how does this process work? Where does it go? So if I can zoom out just a little bit and we'll walk down the path. Why does the Bureau, when they issue an RFI before a proposed rule, why do they issue an RFI before a proposed rule?
That's a great question. I think if you take a step back, a lot of rules that come out, especially from the CFPB, starting in its earliest days, were mandated by statute. So Congress passes a statute like the Dodd-Frank Act that says, okay, CFPB issue these particular rules, and then the CFPB will undertake that rulemaking and put out, in many cases, just a proposed rule, and then a final rule after taking comments and considering them and amending the proposed rule based on those comments. But sometimes if the CFPB is undertaking a rulemaking on its own, it might not know exactly what to do. It might have an overarching goal, like in this case with the RFI, of increasing access to mortgage credit. And it might have an idea of how to do that. To say, okay, well, let's amend the TRID rule because that's a major cost for the industry in closing these loans. But it might not know exactly what changes should be made at this point. And I think you could say it's because of partly because the CFPB just hasn't been researching the effects of the TRID rule on the mortgage market. Dodd-Frank requires a look back 5 years after the effective date of a major rule, like TRID. It did one for ATRQM. It does them for other major rules. But if you do go back and look at the TRID 5-year look back, it really wasn't the most substantive product. It's not like a deep dive into how TRID was performing. And so I think that in part because of that, the CFPB really doesn't know exactly what specific changes to make to TRID to reduce the industry's compliance burden and also benefit consumers. And that's part of the reason why an RFI has come out. And also there's other areas that are being considered by the CFPB in this RFI as well, like rescission, which is a really hot topic, and any changes to rescission rules can really get a lot of negative feedback from consumer advocacy organizations. So CFPB might said, well, let's just dip our toe in the water on rescission here and see what kind of feedback we get back. And then also for the contemplated potential integrated disclosure rule for reverse mortgages, the CFPB just might want to get a first take in general from the industry on what changes that the industry would like to see to the reverse mortgage disclosures currently, or whether a more fulsome integrated disclosure rule might make sense. So I think it's a way to get information when the agency doesn't know exactly what changes it wants to make to the rules.
That makes good sense. All right. Well, in Washington and around the country, we're having a very large conversation right now about the water's edge of agencies and bureaus and what requires Congress and what the executive can and can't do and all of that. And it's interesting that this is coming kind of during some of those big conversations. And also, again, we have a lot of people in industry who haven't been through something like this. And so I'm wondering if we can help people learn some of the examples in this RFI, but the difference between administrative changes, regulatory changes, and statutory changes requiring Congress, because I've heard some commentary about some of the topics that are coming up in this request for information may actually require congressional approval instead of just an agency change. Can you talk about that a little bit?
Sure. So the way the TRID rule is mandated by Congress, there's a provision in TILA and a provision in RESPA that says, hey, CFPB, you've got to issue integrated disclosures, and that's it. And it gives the CFPB a lot of discretion. There's certain required information that needs to be included in the forms, but there's not a lot of specific guidance on how to accomplish that. There's other statutory requirements that affect the timing of the forms and other statutory requirements as well that get implemented in the rule. But for the most part, the CFPB has a lot of discretion. While there are a lot of questions right now about how much authority agencies have to essentially make their own requirements and rules, especially after the SCOTUS opinion in Loper Bright, which got rid of the Chevron doctrine that said that the courts will defer to reasonable agency interpretations of ambiguous statutes and kind of put the onus on the courts to interpret the statutes. I think the courts are still going to defer to an agency when the statute expressly gives the agency discretion, like you could argue it does for something like the TRID rule. Now, there are certain areas of TRID that might go further than a court thinks that Congress gave it discretion. Like, for example, the tolerances. Like, there's nothing in the statute that requires something like the tolerances or even mentions something like the tolerance regime under TRID. Now, the tolerances were first promulgated by HUD in its revised GFE rule in 2010, and essentially it was adopted in TRID as a continuation of that regime. It was modified in certain ways that made it more onerous for the industry. But that could be an area where industry says, well, the CFPB didn't have the statutory authority to promulgate these tolerances. It's not within your discretion that Congress gave you. Congress gave you discretion just for the forms, yada, yada. You can see how that argument can be played out. But so there could be question marks surrounding how far the CFPB can go. And that could be something that's commented on in response to the RFI. I don't think there haven't been any legal challenges to the TRID rule yet, I should say. That door is still open, I guess, because of the Corner Post opinion. But
yes,
but yeah. I think it could be something that's commented on in response to the RFI and potentially subject to future challenges. And hopefully that answers your question.
Yeah, it does. Thank you. And I wondered too, so let's say we have some folks out there that say, I have some opinions, I have some comments. So once the comment period closes, like what happens next? Who reviews them? How much weight do comments carry, really? And then let's just walk down the process flow after that for people that aren't familiar or who haven't done it in a while and might be a little rusty.
Yeah. Yeah. So the comment period is on or before August 10th. And so there's not a lot of time left, but hopefully those who haven't started working on it will find the time if they would like to comment. You still got over 10 days. And so I think that's enough time to put together a comment. What happens after that is the agency does review them, right? So a lot of clients come to me after something like this comes out from the Bureau, any RFI, but especially this one because it relates to TRID. A lot of clients say, should I comment on this? There's no real tangible benefit. I don't want to spend the money on something and just throw it out the window. And my answer is, well, there might not be a tangible benefit right away. It's not like you're getting a change to the rule on day one after you submit the comment, but the comments are reviewed by the agency. The agency will review each and every comment. I know that for the TRID proposal, we did review each and every comment and really thought through them and even parse them through issue by issue by issue so we could discuss them, right? So we said, well, this comment discusses these 10 issues and we'll split them up and share it among the agency staff that are working on those particular issues. There's a lot of work that goes into reviewing these comments. And so the comment will be reviewed and considered. I think that's the benefit of it. Somebody actually at the agency is going to listen to what you have to say and maybe not do everything you want or do anything you want, but it will be considered. Case in point, the CFPB actually mentioned responses to RFIs that it had issued years ago. And so it does indicate that these comment letters are considered by the CFPB and could still, even years later, result in changes to the rules. There is, I think, a benefit to submitting a comment.
Well, and just to help people understand that every comment letter doesn't need to contain legal analysis, although nice if it does, but also operational burdens, I'm assuming. Consumer impact definitely carries weight. Cost data, unintended consequences. I'm wondering, are those the types of things that make a comment more effective? Are there more or less effective ways to comment?
Yeah, the CFPB loves data. That gives them something to point to in a proposed rule to say, well, the cost to originate is X, or it takes this many days to originate a loan now, whereas back before this rule was issued, it took Y days. Like any form of data. Those are just a couple examples. Mm-hmm. And that gives them something black and white to point to say this is a problem that we're trying to solve. Say there would be a benefit to changing this rule. And so data, you don't need to have some kind of legal opinion in your comment letter. It could just be factual issues that you've encountered, even trying to comply with the rule or operationalize it. So comment letter doesn't mean a legal memorandum, basically. You should just put down what you want the agency to consider.
All right. So after they've received the answers to the RFI and done the analysis, what typically are the next steps in the process?
So the next steps would be to consider all the comments and then start crafting a proposed rule. And a lot of the times you don't know how long that time period to get a proposed rule out is going to be because there's no statutory mandate. There's no statutory deadline to get an amendment out. And so unfortunately, it's not like you're going to see a proposed, you could say, okay, well, we're going to see a proposed rule in 90 days after the comment period ends. That's just probably not going to be the case. The CFPB doesn't have an idea of what changes it wants to do. A proposed rule will probably take some time because it needs to weigh different options that are laid out in the comments, discuss them internally, discuss them not just within the regulations office of the CFPB, but in the division as a whole with its markets office. The division I'm referring to is the Division of Research, Markets, and Regulations. And so the regulations officer, the attorneys that write the rules, the markets office are analysts that analyze the marketplace. And then you also have the research office, which are the economists. And so the rule would have to be discussed with all of those different offices. And then it would be discussed through an inter-office process with different offices at the Bureau. And then it goes further up the chain to management. And so there's an internal process. I don't know what the exactly internal process is now. I haven't been at the CFPB for a number of years, but it's probably something like that. And so that process just takes time. And without a statutory mandate to get a proposed rule or even a final rule out by a certain date, we just don't know when a proposed rule would come out. One thing you could think about is how much time is left in this administration. Will they be pushing to get a proposed rule out so they could issue a final rule before there's a potential change in administration? That could be the case. And if that is the case, then you can kind of work back the time period from the end of this administration to say, okay, well, this is how long it might take to do a final rule. This is how long the comment period might be for a proposed rule. So this might be when they issue, at least by this date, a proposed rule. And so that's potentially a way to think about it.
Okay, so proposed rule will follow if there's going to be one at some point. Then we've got the public comment period, and then we would move to a final rule with ideally, and Rich, I'm going to play an old favorite, with ideally enough of an implementation window that industry could get ready so that it can execute thoroughly.
Right. And it depends what the final rule looks like, right? So if there's a lot of operational changes that need to be made, hopefully there is that window, the implementation period that's lengthy, so that industry can implement those changes. Like, for example, if there are a lot of changes to the forms, like we talked about last week, probably there won't be, but let's just, for sake of example, if there are a ton of changes to the forms, that involves changes from the technology companies that need to be integrated with software across the industry. And so that would take a long time to implement. So hopefully there's a long implementation period. But let's say the CFPB tries to do this quick and dirty and just put in a bunch of official staff commentary to give guidance to the industry on certain issues that were raised in the comments. Well, maybe that could be a short implementation period and become effective sooner and have more of a chance of kind of being in the ecosystem before there's a change in administration. And so actually the CFPB might weigh that in how it handles the changes it proposes. But that's going to be how it looks, like you were saying. It's if there are major changes, it'll be a longer implementation period. If there's just guidance in the rule, it'll be a shorter implementation period. But there has to be some kind of implementation period, usually after a final rule is issued, unless it's just making some technical fixes.
All right. Well, I hope that we've helped everybody understand that this is something they need to keep a watch on, A. B, ideally that they should feel entitled, and we encourage them to register their comments. Anytime that those comments can be supported by data, which is especially hard in the title and settlement world because most of it isn't ours to share, but there are some. What's your percentage of closings that have been delayed because of the 3-day right to rescind? Those sorts of pieces of data they do have. I think we've covered the fact that they don't need to have a JD or an MBA in order to comment.
Right.
Although, if they would feel better with somebody with a JD coming in beside them to help, there are plenty of you that assist in these things.
Right. I'm glad you mentioned that, because a lot of clients, they say, well, we don't want to comment under our own name because we just don't want the spotlight on us, right? So
Sure.
can you submit a comment letter for us? And that's fine. As long as the comment letter is submitted and it has the ideas you want to convey to the Bureau, it's going to be in the Bureau's hands. If it's your name that's on it, fine. If it's not, if it's under a law firm's name, that's fine too. The comments will still be weighed. And on the data piece, I'm glad you raised that also. Aggregate data, like you mentioned, is useful. Aggregate anonymized data, obviously, because you don't want to give any personally identifiable information. But that's actually even probably more helpful than saying this problem happened on this one loan and then handing over anecdotal stories to the Bureau. That kind of stuff isn't going to be helpful. I think like aggregate data that conveys a larger picture that shows that something's actually happening is going to be more useful.
Agreed. Well, thanks for helping us understand how to think about this and to act on it. And obviously, to all of your points, this is going to be a process. And so we appreciate you being a resource for us to help get us through to the other side, whatever the other side looks like. We don't yet know for sure. Thanks, Rich, for being here with us.
My pleasure. Good talking to you.
Well, I think today's conversation was a reminder for us all that regulations don't just appear one morning out of thin air. They're built over time, shaped by statutes, agency experience, public comments, operational realities, and yes, sometimes by the very people who have to live with them every day. If today's conversation did anything, I hope it convinced you that your experience has value. Whether you're a lender, title professional, settlement agent, software provider, attorney, or compliance officer, you've seen firsthand what works and what doesn't. If you have data, If you've encountered unintended consequences, or if you have ideas for making these rules work better for consumers while remaining practical for the industry, this is your opportunity to speak up. We'll include links in today's show notes to the CFPB's request for information and Rich's excellent analysis so you can explore it further. Thanks for joining us for these 2 conversations with Rich. We'll see you next time on Keys to Real Estate, where we're always going to keep you in the know because knowledge is a competitive advantage.